Disciplinary actions Guzman v. CA, Supra. Facts: DLG Secretary issued against Mayor Guzman 3 separate orders of 60-day preventive suspensions dated AUG 11-1988, OCT 11-1988, and MAY 3-1990. A fourth order was issued on JULY 3, 1991. On August 5, 1991, SC issued order that the first 3 suspensions are affirmed provided that Guzman may not be made to serve future suspensions on account of any of the remaining admin charges against him. Guzman filed a petition for mandamus with manifestation in compliance, alleging that he had already fully served the suspension orders issued against him, in compliance with the August 5 SC order, and that he should be allowed to reassume his office starting September 4, 1991. Held. Simultaneous service of the third and fourth orders of suspension can be allowed under the bizarre circumstances of CAB. It would work in favor of Guzman, an elective official, and it presumably will favor the local constituency and certainly lessen if not offset the harsh effects of whatever motive may be behind the intriguing action of DLG seconds in issuing the successive suspension orders, especially when he could have pursued a consolidated effort. SC takes judicial notice of recently approved LGC which provides, under SEC 6.3 as to imposition of preventive suspensions, that SEC 6.3 that any single preventive suspension of local elective official shall not extend beyond 60 days. Provided, further, that in the event that several administrative cases are filed against an elective official, he cannot be preventively suspended for more than 90 days within a single year on the same ground or grounds existing and known at the time of the first suspension. Espiritu v. Melgar. Facts: Ramir Gehring filed a sworn letter complaint with Secretary Luis Santos of DILG charging Mayor Nelson Melgar of Najan, Oriental Mindoro, with grave misconduct, oppression, abuse of authority, culpable violation of the Constitution and conduct prejudicial to the best interest of the public service. Melgar allegedly assaulted Gehring and ordered his arrest and detention in the municipal jail of Najan without filing any charges until his release the following day. An identical letter complaint was filed by Gehring with Provincial Governor of Oriental Mindoro Benjamin Espiritu, accusing Melgar of the same violations. A third complaint filed by Gehring with the Presidential Action Center, OP. Mayor Melgar submitted his answer wherein he said that while he was delivering a speech during a graduation ceremony, Gehring suddenly clapped, causing disturbance on the part of the audience. When the mayor ended his speech, he instructed a policeman to investigate Gehring. It appeared that Gehring was drunk. The mayor also presented medical certificate proving that Gehring was not hurt. A ballison was then taken from Gehring. The mayor informed Gehring to go home, but he refused to go and only did so the following morning. The Sangguniang Panlalawigan of Oriental Mindoro passed Resolution No. 55, recommending to the provincial governor that the mayor be preventively suspended for 45 days pending the investigation of the administrative complaint. When the mayor received the order of suspension, he filed a petition for certiorari with preliminary injunction with prayer for restraining order in the RDC of Oriental Mindoro, alleging that the order of suspension was an arrogant, despotic and arbitrary abuse of power by the governor. The RDC judge issued a writ of preliminary injunction enjoining Governor Espiritu from implementing the order of suspension against Mayor Melgar on appeal. Petitioner contends that the trial judge erred in granting the preliminary injunction since the governor is empowered under Sector 63 LGC to place an elective municipal official under preventive suspension pending decision of an administrative case against the elective municipal official. Also, under Sector 61 LGC, the Sangguniang Panlalawigan has jurisdiction over the complaints against any municipal official, while Section 19 of the Judiciary Reorganization Act of 1930 withdrew from RTC's jurisdictions over such cases. Also, the mayor has a remedy of appeal under Sector 66 LGC. Issue: 1. The governor has the power to suspend the mayor. Held yes ratio. Under Section 63 LGC, the provincial governor of Oriental Mindoro is authorized by law to preventively suspend the municipal mayor of Nakhon at any time after the issues had been joined and any of the following grounds were shown to exist. When there is reasonable ground to believe that the respondent has committed the act or acts complained of, when the evidence of culpability is strong, when the gravity of the offense so warrants, or when the continuance in office of the respondent could influence the witnesses or pose a threat to the safety and integrity of the records and other evidence. There is nothing improper in suspending an officer before the charges against him are heard and before he is given an opportunity to prove his innocence. Preventive suspension is allowed so that the respondent may not hamper the normal course of the investigation through the use of his influence and authority over possible witnesses. Since the mayor believed that his preventive suspension was unjustified and politically motivated, he should have sought relief first from the Secretary of DILC, not from the courts. Mayor Melger's direct recourse to the courts without exhausting administrative remedies was premature. The RDC had no jurisdiction over special civil action No. R 5003 and gravely abused its discretion in refusing to dismiss the case. There may exist honest differences of opinion with regard to the seriousness of the charges, or as to whether they warrant disciplinary action. However, as a general rule, the office or body that is invested with the power of removal or suspension should be the sole judge of the necessity and sufficiency of the cause. So, unless a flagrant abuse of the exercise of that power is shown, public policy and a becoming regard for the principle of separation of powers demand that the action of said officer or body should be left undisturbed. However, in this particular case, since the 60-day preventive suspension of Mayor Melger was maintained by the temporary restraining order which we issued on August 6, 1991, and therefore has already been served, he is deemed reinstated in office without prejudice to the continuation of the administrative investigation of the charges against him.